Assalamualaikum to all students. I hope that you all are doing fine. Alright, for today we are going to discuss on the final chapter in the syllabus, which is under law of agency. So we go back to chapter 3. Last lecture we have covered the topic of negotiable instrument, which we had focused on the check only. Right. So for law of agency, the learning outcomes for today's lecture is first, at the end of the lesson, student is able to know the nature of law of agency. In other words, student is able to define what is agency contract, who are the parties to the contract, okay, followed by second learning outcome, student is able to discuss the various form of creation of agency. In what ways agency may be created. Okay, for the third subtopic, classes of agent and the authority of the agents. For these two topics, okay, I want you to read by yourself. Okay, and the next learning outcome for today's lecture is, at the end of the lesson, student is able to explain the duties of agent and principal, and they are able to apply the duties of agent and principal into the given situations. And last but not least is, student is able to discuss the two methods of termination of agency. Alright, so for the purpose of lecture today, we are going to discuss first, second, okay, fifth and sixth subtopics only. Alright, as for an introduction, law of agency is governed under Part 10 of the Contracts Act 1950. Okay, so we are using the same Contracts Act as you study law of contract. Okay, so later when you refer to Contracts Act 1950, okay, you will notice that there is another part, okay, part 10, which only discuss on law of agency. So what is an agency contract? Basically, it is a relationship which exists between the principal and agent who has been authorized to act for him or represent him in dealings with others. Normally, principal will give instruction to the agent. Principal will appoint an agent to act on his behalf. Who is a principal? Principal is the person for whom or on whose behalf the agent acts. In other words, the one who appoints the agent to carry on instruction. And then agent may be defined as a person who has been authorized to act on behalf of the principal, as stated in section 135 of the Contracts Act. Okay, under law of agency, there are two effects of contract. First is the contract which governs the relationship between principal and the agent, and this is known as agency contract. This is where the agent derives his authority to act for and on his behalf. And the second type of contract under law of agency is the contract made between principal and the third party through the medium of the agent. Okay, so the second contract will govern the contract made between principal and the third party through the medium of the agent. Okay, whether there is any qualification to be a principal. Okay, for a principal, okay, it is a quite strict. Okay, you need to refer to section 136, where it states that person must with full contractual capacity. In other words, person must fulfill the requirements to enter into valid contract. For example, in order to be a principal, a person must attain the age of majority and he must sound mind. Why we need a sound mind? Because this will enable the person or the principal to enter into valid contract so that he is capable to understand the nature of the contract. How about an agent? In order to be an agent, anyone can be appointed by the principal, including a minor, but agent will not be liable for any loss caused by him to the principal, as stated under section 137 of the Contracts Act. In other words, if you appoint a minor as your agent, in the event that the minor or the good from the third party and fail to pay for the good, so you as a principal, as a major principal, is liable against the third party. Minor is not liable. This is a consequence if you appoint minor as your agent. Okay, so it is advisable to appoint a person who attained the age of majority. Okay, next we proceed with the creation or formation of agency. In what ways agency can be formed? Alright, an agency contract may be formed through the following means. Okay, basically there are 5 methods of appointment of agency. First, we start with an express appointment by the principal, as stated under section 150 of the Contracts Act. This is meant by an express authorization which can be either in writing or orally. Okay, for example, let's say today, okay, I said that, alright, starting from today, I appoint Ali as my agent. So this is an express appointment made by me as the principal. And only agent whose appointment is under seal can enter into contract under seal. Seal here means that contract that is more secure. Right? Okay, next method is by an implied appointment. Implied is opposite to express appointment and based off 3 situations. Okay, which cover first situation based on the case or habit, next based on the relationship between husband and wife, and third is between the partnership. Okay, the first type of implied appointment, which it can be implied from the circumstances of the case or habit. Okay, as stated under section 140 of the Contracts Act, this is when one person by his words or conduct holds out another person as having authority to act for him. In other words, impliedly, okay, you appoint other person as your agent, but this is not an express appointment. Okay, so you may refer to the case of Chan Yin T against William Jacks and Co. Malaya Limited. In this case, Chan, the appellant, together with a minor Yong, were registered as partners in a business. At a meeting with the respondent's representative, respondents here is referring to the third party, William Jacks. Okay, Chan had claimed that Yong was his partner, and business then commenced between the two parties, whereby the goods were supplied to Yong, a minor, but the price was not paid. So the respondent obtained judgment against Chan and Yong. So irrespective whether Yong was Chan's partner, Yong had the authority to do things on Chan's behalf, and as such, Chan was liable for Yong's act. This is because, okay, impliedly, Chan told the third party here that Yong as his agent. Okay, so this is based on implied appointment where one person by his words or conduct holds out another person as his agent. Okay, next, implied appointment based on the relationship between principal and agent that may exist between husband and wife. Okay, the general rule is that when husband and wife live together, there is a presumption that the wife has authority to pledge her husband credit for necessaries suited to their style of living. Okay, in other words, wife will be considered as an agent to her husband. So wife has authority to pledge her husband's credit. In other words, husband a credit card, okay, husband a money. Okay, however, this rule can be rebutted by husband, proving that he expressly forbids his wife to pledge his credit, he expressly warns the tradesman not to supply his wife with goods or credits, or his wife is sufficiently provided for with goods of the kind in question, his wife is given a sufficient allowance for buying the goods without having to pledge her husband's credit, or the older, though necessaries is unreasonable taking into consideration her husband's income at that time, meaning that husband may rebut the presumptions. And the third types of implied appointment based on Section 7 of the Partnership Act 1961. In partnership business, partners are each other's agent when contracting in the course of the business. Okay, I bet that you still remember what you learned in the first chapter, characteristic of partnership. As you notice, one of the characteristics of partnership is when you form a partnership, you will become an agent and principal against each other. Alright, next move on to the third types of appointments of agency by ratification. What is meant by ratification? Ratify means that the certifications or acceptance by the principal for an act done without authority or exceeding the authority given. Okay, so please bear in mind that ratification means certification. In other words, in bahasa kita panggil pengesahan, confirmation. Okay, when the act's done without authority or exceeding the authority given. Okay, so in order to discuss on the agency by ratifications, there are two prerequisite elements that must be proved. First, an agent who was duly appointed has exceeded his authority, or a person who has no authority to act for the principal but has acted as if he has the authority. Meaning that, okay, in order to establish agency by ratification, you must prove that there must be an unauthorized act. Unauthorized act can be either agent has exceeded his authority or a person has no authority and then he acts on behalf of the principal. So what are the effects of ratification? The principal can either choose to reject the contract since he has not authorized it, or accept the contract so made, then it means ratification of contract. Okay, just now I mentioned that okay, the agent has no authority to act. Okay, I give you one illustration. Okay, let's say we have two parties here, Ali and Abu. Okay, Ali and Abu. Ali is a principal. Okay, Ali is a principal and Abu is the agent. Okay, in the agency contract, Ali give instructions to Abu to purchase a house at the price of 500,000 ringgit. So this is the maximum price allowed by Ali as the principal. However, later, Abu found the house and he bought the house at 600,000 ringgit. In other words, Abu here has exceeded his authority as agent because his authority is only to acquire the house maximum at 500,000 ringgit, but he bought at 600,000 ringgit. So in this situation, principal need to ratify the contract. If the principal Ali choose to reject the contract, then who is liable? Abu will liable against the third party. But if Ali choose to accept the contract, meaning that Ali is liable against the third party. Contract is binding on the principal as if the agent had been properly authorized beforehand. So this is when the ratification made by the principal. The authority is under section 149 of the Contracts Act, where acts are done by one person on behalf of another but without his knowledge or authority, he may elect to ratify or to disown the acts. If he ratifies, the same effect will follow as if they had been performed by his authority. And please bear in mind that ratification has a retrospective effect. So what does it mean by retrospective effect? Okay, based on the case of Bolton and Partners Limited against Lambert, contract is effective from the date when it was made and not from the date it was ratified by the principal. Hence, the defendant bound by the contract with the company. Okay, please refer again the illustration between Ali and Abu just now. Let's say that Abu entered into contract with the third party on 1st July, okay, 2019, and Ali ratified the contract on 1st August 2019. So, if ratification will apply retrospective effect, then it will go back to the date when the contract was made, okay, which was on 1st July 2019. Okay, in order to ratify the contract, there are 9 conditions must be fulfilled. First condition, you must prove that there must be unauthorized act. As I mentioned earlier, unauthorized can be either a person without authority or agents exceeds the given authority. Second condition, the unauthorized contract must be recognized by law. So even the contract, even the authority is even the authority is not given by the principal, okay, but the unauthorized act still considered as legal, okay, and recognized by law. Okay, for example, you may refer to the case of Brooke against Hook. In this case, court held that the principal may not ratify a contract in which his signature had been forged. So there is an element of criminals here. Okay, and forgery is an illegal act. So you must prove that unauthorized contracts there must be recognized by law. Third, agent must, at the time of the contract, expressly act as agent for the principal. In other words, when he entered into contract with the third party, he must use the principal's name, not his own name. Example of case in Kelly Maxted and Co. against Duran. In this case, Robert, an agent, was authorized by the appellants to buy wheat at a certain price. However, he had exceeded his authority. In what ways? First, when he buying the wheat at a higher price than authorized, so he exceeds his authority, and he buying it in his own name but intending it for Kelly. So he used his own name to enter into contract. So in this case, the principal was not liable to the third party. This is because Kelly had not ratified Robert's contract, since Robert at the time of the contract did not profess to act as agent because he entered into contract with the third party using his own name. Next, we must prove that agent must have a principal at the time of the contract. Okay, next, principal must have contractual capacity. Just now we discussed the qualification of principal. So at the time when the contract is made and at the time of the ratification. So we refer back to section 11 of the Contracts Act. Okay, for valid capacity to enter into contract, reach the age of majority, sound mind, and must not be disqualified by any law. Next, the principal must at the time of ratification have full knowledge of all material facts. In other words, principal must know everything regarding the contract. Okay, for example, the price of the house, okay, bought by the agent. Okay, and the principal must ratify the whole act or contract. He cannot accept only part of the contract because under section 152, partial ratification is equivalent to total ratification. And then next, ratification must be made within a reasonable time. So what is amount to reasonable time? It depends on the subject matter of the contract. Okay, example, in the case of Metropolitan Asylums brought against Kingham and Sons, it was held that principals purported ratification on the agent's contract to buy eggs without authority 1 week after was void. So we follow the facts and circumstances of the case in order to determine whether the time is reasonable or not. Next, ratification must not injure or affect the interests of a third party. Okay, so the last condition, you must prove that at the moment of the principal want to ratify the contract, you must prove that the ratification will not harm or injure the interest of the third party, because under law of agency, we must protect the interest of principal and as well as the interest of the third party. Okay, so next we discuss on the appointment by necessity.